Representing the government is Solicitor General Elizabeth B. Prelogar. Now, she opened her defense with,
"Throughout this litigation and at times this morning, petitioners have sought to characterize this case as presenting a fundamental question of the separation of powers and a test of Article 3. Will courts continue to say what the law is?"
While the belief is commonly held, the purpose of Article 3 courts is not to arbitrarily say what the law is, but to decide controversies based on those laws. Since the specifics of those laws need to be considered when applied to specific cases, there's obviously some interpretation that goes along with the role of a judge. General Prelogar then sets up a straw man for the court.
Imagine, for example, if the statute said in Chevron, stationary source as defined by the administrator. I take both petitioners to give that up and recognize that is a delegation and courts should respect that. The role of the court in that circumstance is to make sure that the agency has followed the proper procedures and stayed within whatever outer bounds Congress itself has set. And all of that complies with the Constitution, of course, because Congress has Article 1 authority to delegate gap-filling authority to agencies, and the executive has core Article 2 authority to fill in those gaps.
First, General Prelogar attempts to redirect the question at hand. Petitioners are questioning the deference to the agency when Congress is silent, not when they have explicitly delegated authority to an agency. This is based on two fundamental errors by General Prelogar. First, nothing in the Constitution delegates to Congress the authority to delegate to another the power to fill in the gaps in their legislation. Second, neither does the Constitution delegate to the executive branch the authority to fill those gaps. Still, there's a more fundamental constitutional flaw in General Prelogar's argument.
If Congress can expressly vest an agency with authority to interpret the law through an express delegation, then it can do the same thing implicitly, especially in a world where Congress has to provide the agency with the express authority to carry the statute into operation with the force and effect of law.
General Prelogar's straw man doesn't show Congress vesting authority to interpret the law, but to apply the law. See, in her argument, Congress gives the administrator authority to define the term stationary source, not to interpret the law whichever way they want. To make matters worse, General Prelogar claims that when Congress does not tell an agency they can do something, that means they have the power to do it. This not only violates the plain language of the Constitution, but places the executive agencies above the very Congress that created it. After all, if any agency can interpret for itself what the law means, their word becomes law. See, only after those harmed by such totalitarian rule have spent years and untold dollars pursuing a court case can they expect any sort of redress of grievance for those agencies' actions. And then only if the court finds the agency's interpretations unreasonable. A very fickle standard indeed. Should Congress draft new legislation to restore its intent to the law, we once again would have a long and fraught process, one that does not guarantee the original intent of the law is applied.